Hello, my name is Brett Davies. I'm a barrister and solicitor, and today we are going to build a simple mutual will. Now, this is a will from mum to dad to mum, and it has no testamentary trust in it. It's a simple will, so people that don't have that much money, so a young couple just starting out, perhaps without children, or a young couple that don't have many assets. So here we are. There's the law firm's website, and it is a law firm's website. Going to go estate planning and wills. So I'm going to I could have actually started building a will there, but I'm just going to actually go into it this way. Last will and testament. So it's a single will, mutual wills. So there's two mutual wills and there's two single wills. Today we're going to build a mutual simple will. If you've got lots of money, you really should do a mutual three-generational testamentary trust. If you're by yourself, so your husband's died or your wife's, you never got married, you don't have a life partner, you should consider a single will with testamentary trust or a single will which is without tax planning. But today we're going to build a mutual simple will for mum and dad, and let's begin the process. So this is interesting. So there's some information here. That's great. There's a telephone number I can ring here. And I can also see a sample of the document. That's really great. So every single document we sell online, you can see a sample of the document, a full sample with actual hints on it. And here's the sample will. Now, obviously, the will could be different depending on how you answer the questions. This person, Catherine V. Van Green, her will may be different to yours, but they're of similar ilk. Now, firstly, if you're an accountant, financial advisor, or lawyer, you can put your logo at the top by just downloading it from another page. And there it is. There's the will. Oh, that's good. So she's appointed 3 executors. Excellent. And she's done a Pacific gift. I don't like Pacific gifts. We'll get to that in a minute. But a Mercedes-Benz Sports is quite a nice Pacific gift. And she's given everything to 1, 2, 3, 4 people. And she's nominated someone at 99 years of age. Young Ronald must be a bit of a spendthrift or perhaps an alcoholic or suffering a mental disorder, so we'll come back to that. Minors, testamentary trusts, contemplation of marriage, divorce. She's got everything in this will, and then she should sign it. And there is the next person. These are mutual wills, all to mum or to dad, dad to mum. Looking good, looking very good. And at the very end of both those mutual wills will be a covering letter from us on the law firm's letterhead, confirming that we built the document, we own it, and we carry the PI insurance and the copyright of this document. Well, that is all wonderful, but I want to start building the document. I can actually go to the checklist, but I'm getting excited. I'm going to start building now. I'm going to log in. If you haven't logged in before, you'll be asked for your username and your email. I've now logged in, and I can actually pick up any data from any of my clients. So let's say we're doing Thomas's will. If I've got data about Thomas, I could select that, and all that information will be fed into the will. But I will just start the will from fresh. Wow, here we go. Mutual wills, no testamentary trust. We're in play. So I can put the husband first or the wife first. I'm going to put the wife first. So we are doing Karen Nugget's will, which was born in 1945 rather, and she lives in Victoria. So let's now press next and put in Karen's life partner's name. Now this could be Karen's gay partner, it could be her husband, it could be her de facto partner. It makes no difference to the validity of the will. And now we have the spouse's full name, and he's a man. It's a beautiful Greek name for him there. Gamanon West, date of birth, the address bar, put that in there, and just populated it all. That was really nice. And now I'm going to press next. Now if I press next and get a green tick, that means that our website's logic flow is happy that the data has been all completed. Now the next question is other names. Well, what do I care about other names? If Karen has names or has assets in another name, like perhaps a previous name when she was single, then we should press yes and put that name in here. But in this case, Karen does not have any other assets other than the name of Karen Ann Nugget, and it's the same with Amagon. He's got no other names as well. He might have had a nickname, Aga, in which case we better put him in there because he might have a bank account called Aga West. So he'll have to have an alias name, which means in his will, which we will build in a few seconds, he'll have that also known as. That's pretty good and makes it easy to get probate and easy to transfer assets at a later time. Now with age of majority, this is the general age that beneficiaries can get the wealth, and I'm a bit concerned between 18. I'm going to make it 21. So anyone under 21 will not be able to get their assets until they're 21. I won't press next this time. I'm just going to press the executor clause. I've already got a tick there, so I'm doing well. If you find a cross or something different, you need to go back and correct it and make sure. So the executors are the people that carry out your wishes in your will. These are the backup executors because obviously what you've got is you've got the husband leaving everything to the wife, and you've got the wife leaving everything to the husband. So Karen has everything to Mr. West, and Mr. West has everything to Karen, and they're each other's executors. So these are only executors once both of them die, and they have 2 children, and one is under 18 years of age. But they're still going to appoint those 2 children, and in the unlikely event either of them are under 21 years of age, they're going to have a backup executor, perhaps a loving uncle. So let's get the 2 children in first. So normally you'd put the children in by order of their age. So the oldest child goes first. Their firstborn child was Ajax Wester. Different surname, it's interesting, but that's fine. And he lives where he lives. Interestingly, at what age? Now he is already 18, but he's not yet 21. So I'm just actually going to make that 21 years of age. Normally I'd just leave it blank if he's already of age, but he's actually under 21. And now I'm going to put in the daughter's name. So it says here, add another backup executor. That'll be my second child. And they had a beautiful girl as their second child. So here's the second child, Agatha, Mrs. Agatha, or Miss Agatha West. And we're going to make her also 21 years of age in this instance. She's actually only 16 years of age, so she couldn't be possibly an executor if she's 18, but we'll still put her in because it's likely that when Karen and Mr. and Mrs. Nugget die, they're probably the children will be in their 60 years of age. So I want to add a third executor, being an uncle, just in case any of these children are under 21, I've got a backup executor. Obviously, if the children are both over 21, the backup executor might well have died, or he's not needed, so he can just renounce. So I'll put in Uncle Harry. Now I'm going to leave blank because he is well into his 40s now, so I'll leave the blank as to what age he is, and he is in Brisbane. In Tenerife, there we go. So I now have 3 executors. These are backup executors, so I've appointed my wife, she's appointed me, and I've got backup executors of the 2 children, one of which is only 16, but that doesn't matter, and I've even got a third executor there, being the uncle. So I'm pretty well set now. I'm happy with that. I'm now going to go to Pacific Gifts. Will I get a green tick? I did. Good. Now with Pacific Gifts, it's always best to say no. Now, I know you've got beautiful artwork. I know you've got the ladro. I know that you'd like to give the car to the boy and the garage tools to the boy and the girl's going to get the jewellery. I know all that. But it's still better not to put a Pacific Gift in. Leave everything equally to the 2 children after you both die, and they can work it out themselves. But if you do want to put a Pacific Gift in, just press yes and you put the Pacific Gift. E-type Jaguar, the name of the person. But it's never a good idea to put in Pacific Gifts. There's also another more sinister reason, and that is that when you die and your will is lodged with the Supreme Court for probate, the document becomes a public record for a Channel 7 news crew or the Australian Taxation Office, those sorts of problems. It becomes a public record. I would not select specific gifts. So I'm going to move straight to residuary beneficiaries. So these are mutual wills, simple mutual wills. I've left everything to mum, everything to dad. Everything after that, only after mum and dad both die. So maybe mum dies 20 years earlier, maybe dad dies with her, maybe dad dies 20 years after his wife. It doesn't make any difference. Both parents are now dead, and everything's going to go equally to the children. So I'm going to put in the 2 residuary beneficiaries here. And again, I'm putting them in the order of the name. So I put the son's name in first. So I now have my 2 children, or the client's 2 children in there, the Ajax. He's getting 50%, and he's 21. And Agatar West is getting everything 15%. At what age? I'll make it 21. Look, normally I'd make it 18, but I'm just in the mood for 21 today. I'm now going to go to the disaster clause. The disaster clause is only useful if you travel with your children, so that Mr. Karen and Mr. Nugget and the 4 children travel together in a car accident, could be killed, or in an aeroplane accident, could be killed. In that instance, would put yes and would leave half to his side of the family and half to her side of the family. But in this instance, they don't travel anymore. The oldest son doesn't go on holidays with them anymore. It's just the daughter, so it's unlikely they'll be wiped out. Therefore, the disaster clause they don't want to take up, and they press no. Now we're going to guardians. Now, a guardian is very useful to put in a will, because the will is a public document, and you should take advantage of that. And if you have a child under 16 years of age, it says 18, and I like putting the guardianship clause, even if the child is over 16, because it gives an important message to the child as to who will look after them. And in this case, I'm going to make it, because Ajax is now 18, I'm going to have the older boy look after his sister in the very unlikely event that these 2 people, these mum and dad, die in the next couple of months, before the next couple of years before the girl turns 18 herself. It's quite surprising to me that under Australian law, at 16 years of age, a child can leave the home without the parents' permission. I just find that bizarre. So we've taken up the advantage here to have a guardian. In this instance, we've picked the older brother. He's 18 now, and I think that's kind of nice. He can live in the house together in an unlikely event that mum and dad die. So I could pick another guardian, but that will be enough. So now press next. And we're now looking at people who can challenge your will. And there's lots of training videos on this. Basically, the 4 people, the groups of people are your parents, people you sleep with, like a mistress, lover, or spouse, husband or wife, or de facto, your children and your grandchildren, and just read plenty of the hints there. In this instance, this couple's doing what society deems to be normal, everything to each other, everything to the children equally. I'm not saying it's right, it's just what I've done the same thing in my will. But that's what most first marriage couples do, and therefore the chances of being challenged are very remote, and I won't take advantage of the considered person clause. It's not required. Contemplation of marriage is extremely rare you'd ever press yes for this. It's only yes if you are living with someone that you might marry in the future. Now, if you don't marry them, the will remains valid. If you do marry them, because you've pressed yes here, then the will remains valid. If you press no, leave it at no, you then get married, the will's revoked. But in this instance, Mr. and Mrs. Nugget are married, therefore this clause is of no value, so they've pressed no. Contemplation of divorce. This is the case where maybe you're in a de facto relationship, you're married many years ago, you haven't seen your spouse for many years, but something may happen in the future. You may get divorced from her or him, and that would invalidate this will. So in that case, it might have been that Karen was married before. Let's say Karen was in a de facto relationship with Mr. West, and she was still married to someone else. She'd put that person's name in. In this case, these are just a first marriage, happy marriage couple. Now the reference is used predominantly for accountants, financial planners and lawyers that are doing thousands of documents on our website. So they might want to put their reference details in and the client ID, so they can actually track it for in the future. They can actually search on this document and find it again. Maybe they've done powers of attorneys and things as well. And they might want that reference on every single page, and that reference will now appear on every single page. And accountants, financial planners and lawyers, if they want, they can download their corporate logo. And if they have, then they can either have the corporate logo on or corporate logo off. In this case, we'll put the corporate logo on. We now get the opportunity to check everything. So we're a law firm. We carry the PI insurance in this document, so we want to make sure you get another chance to check all the spelling and grammar. So let's have a look. The date of birth looks correct, yes. Full names. There's an alias for the mum. Children's addresses. There's a backup uncle there in case the children are under 21. There's a guardian. That's lovely. That looks good. I am going to lock and build. Now, once I press lock and build, I can't change the document. I'm going to press lock and build, and I'm going to put my credit card details in. Now, I put my credit card details in. Within a few seconds, the document's built, and I can now open it. It's emailed to me. It's stored on our law firm's website, so you can come back in 20 years' time and get it. That's also on your hard drive. And I'm just going to open it up. Let's have a look. You've just created mutual wills, simple wills without any tax planning. There's the accountant or financial planner or lawyer's logo. There's the reference for the accountant. Here it is. So will made by me, Karen, of that address, date of birth. She revokes previous wills. She's got three. Firstly, she appoints her husband as the executor. But if he's too weak or frail or has died or failed to survive by 28 days, then the three backup executors are the two children, Ajax and Agatha, and good old Uncle Harry will be there just in case the children are under the age of 21. If the children are over the age of 21, Harry can still be an executor if he wants, but normally he'd renounce because there's not much work for him to do. The age of majority is normally 18, but they've chosen to appoint it at 21. If my spouse survives by 28 days, then to give the trust fund to my spouse, to my husband. But if he dies before me or fails to live out longer than 28 days, then everything equally to the two children, Ajax and Agatha, 50%. Now, just make sure that you always have 100%, or if it's a third, you make it 33 1/3%. Don't do 33.3% because it won't equal to 100%. There's plenty of hints on that topic. Now, clause 5 says that if Ajax dies before mum and dad and has children, then clause 5 says whatever Ajax would have got will go to Ajax's children. But if Ajax's children are killed in the same car accident, then everything just goes to Agatha. So it's a bloodline gifting provision. Order each other, order the children's children, but if a bloodline's wiped out, it goes back to the remaining bloodline child. Clause 6, what's all that about? Well, in the unlikely event the children have not reached the age of majority, which is 21, then they can still have, but then the executor, which would be Uncle Harry, will be the controller of that. You can still have money for certain things to benefit, such as maintenance, education, advancement, support and benefit, which that obviously means the toilet paper, the sharing the burden of the Coles shop when you buy food, the shelter of the home, but it can also mean a car to get to university with. The daughter might be doing an engineering degree and she at Melbourne University, and she might decide that she wants to need a car. The executor, Uncle Harry, can give her that car. Obviously, when she turns 21, she'll get her half anyway and do whatever she wants to do. Clause 7 is lots of executors' powers, just to make sure that we do lots of different things. There's a testamentary guardianship for infant children, and that points Ajax. So if there are any children under 18, really it's under 16, but we'll call it under 18, then Ajax will be guardian of those children, which will be his sister. Unlikely to have used that because it'd be unlikely that mum and dad will die in the next few years. Clause 9 protects the integrity of the document, so if there's any changes to the law, it doesn't matter. The gifts to each other and the gift to the children remain paramount. That protects the integrity of the will, and Karen will sign it. She signs on each page, but she's also going to sign on the end page as well. And these are mutual wills. So there's the husband, Mr. West. He's got a mirror will, mutual wills. He's got similar, virtually identical wording. And then you've got the covering letter written to Karen and Ugerman. They are being told how to sign the will, witness the will. Now, bearing in mind that, thank you for building your wills with us attached to other wills. Please read through the document. We are the authors and owners of this document. The copyright belongs to us, and we author the document. An accountant, lawyer, or financial advisor may have put data in, filled out the information as mere scribes, but we hold the PI insurance and we are the lawyers. So there's how to sign the will. Lots of good information there. Also about how to challenge, which we've discussed. Get a doctor's certificate to say you're of sound mind, and it's signed by a partner of our law firm. And there it is. You have now produced a mutual will. Everything to mum, mum is everything to you, everything to the children equally. It's a simple will. I'd rather you have done proper estate planning with 3-generational testamentary trusts, but because of whatever reason you've decided the assets are not worthy of putting testamentary trusts in your will, you've opted to do that. If you did want to build a 3-generational testamentary trust, then you should build that document. Now, if you have any questions, we're a law firm, so though there's lots of hints and training videos, you're welcome to telephone any of my lawyers and we'll be happy to give you free legal advice on the building of this document. Enjoy your mutual, simple wills.